Hello everybody. So in this video we are going to cover this chapter called Precedent, and with this precedent we are entering into part 5 of Indian Constitution. And when I am saying part 5 of Indian Constitution, I does not mean part 5 of Lakshmikant. So in Lakshmikant this is the first chapter in portion 3, that is called Central Government. And speaking about Lakshmikant, right, there are 14 or 15 chapters in the central government portion, and this is the first chapter, right? So out of 14 and 15 chapters that you have in Lakshmikant, there are 3 chapters that are very important, and those 3 chapters, the first chapter is this, the second chapter is Parliament, that is Union Legislature, and the third chapter, the third most important chapter is Supreme Court, that is Union Judiciary, right? Coming back to the Constitution, so in Constitution you have Union Government, that is mentioned in part 5 of Indian Constitution. So prior to this we already have covered 4 parts of Indian Constitution. So if you remember, first part of Indian Constitution was dealing with Union Territory, Article 1 to 4. Then second part of Indian Constitution was dealing with citizenship from Article 5 to 12. Then part 3 we have read. Part 3 was dealing with fundamental right from Article 12 to Article 35. Then fourth part of Constitution was dealing with directive principles of the state policy, Article 36 to Article 51, and the fourth A, that was by 42nd Amendment, that was dealing with this fundamental duties, right? So those 4 parts we already have covered. Now we are delving into union government, right? And in union government you do have one chapter dedicated to union executive, and in union executive we do have president. So that is how the structuring of union government portion has been done in Indian Constitution. So enough of introduction, let us enter into slides and let us see how we have planned to cover this chapter. So if you see, these are the number of verticals that we have divided this chapter into. So in first vertical we will raise the question that why president, the position of president is necessary in Indian parliamentary system, right? Thereafter we will see the constitutional evolution of Indian president's power, right? So there we will discuss that what changes 42nd Amendment did in respect to the president's power, then what leeway or what moderation 44th Amendment did, right, in relation to again president's power. In second vertical you have election, then impeachment, eligibility criteria, qualification, then oath. All these things we will study about president. Thereafter in third chapter we will discuss various kind of powers that we have assigned to our president. So you do have legislative power, you do have executive power, you do have financial power, president does have judicial, military, diplomatic power, right? Then we will expand legislative power further and we will discuss ordinance making power of president, right? There we will also discuss how politically this ordinance making power has been abused from time to time. Thereafter in the next leg we will expand this judicial power further, and in that we will discuss pardoning power of president, right? So you had this Nirbhaya case, convicts hanging this year, right? So they had used every available loopholes of the law. They had used that curative petition, review petition, right, mercy, everything that was available to, that can be available to a convict, that had been used by those convicts. So there is every possibility that this year in prelim any such question related with that, right? So that is a current affair topic. Make sure that you cover that particular case, right? What are the process, means case history, right? What process they have followed, right? When a curative petition can be applied, when a special leave petition can be applied, right? When review petition. So what stages a case history goes through, right? What stages a convict goes through, right? So that is not in relation to this chapter. So this chapter, this portion you just have a focus on because of that Nirbhaya case convict. Then in the last leg, if you see, right, we'll discuss the position of president in Indian Constitution, right? In last leg we will also discuss the situational discretion, right? In Indian Constitution the discretionary power of president has not been defined, right? There is something called situational discretion, right? So we'll discuss in last leg what is the situational discretion available to president. So enough of the introduction, enough time we have spent on this introduction. Let us move into the slide and let us see the structure of union government. So this is the parts of Indian Constitution that I was referring to, right? We already have covered these 4 parts of the Constitution. Part 1 dealt with union territory, Article 1 to 4. Part 2 dealt with the citizenship, right, Article 5 to 11. Part 3 dealt with fundamental rights, Article 12 to 35. Now we are somewhere here, the union, right. In union as well, you will see that this Part 5, right, Part 5 has been broken further into something called chapters, right. So in Part 5 you will see, we have this slide for this, right. So in Part 5 you will see these are 22 parts of Indian Constitution, right. So this is in addition to this chapter, just to make things clear to you, right. So I was talking about the chapters that Part 5 does have, right. So this is in a structural format, right. So this is the Part 5 of Indian Constitution that deals with union government, right. You have 99 articles that has been dedicated to this union government, Article 52 to Article 151. Now if you see this Part 5 that I was talking about, right, so this Part 5 has been broken further into the chapters, right, 5 chapters. If you could see C1 chapter 1, C2 chapter 2, so similarly until C5 you have until, so this Part 5, right, that deals with union government, right, although this is not related to this chapter, right, but UPSC has not mentioned Lakshmikant as a reference book, so all the time you need not to emphasize that why you are teaching me other than Lakshmikant, right. There they have mentioned in the syllabus Indian Constitution, right, not the Lakshmikant, right. So it becomes my job to make you understand the structure of Indian union government as well, because under this union government only will be dealing with Supreme Court. So to the Supreme Court, this Constitution says union judiciary. So union judiciary has been dealt in chapter 4 of Indian Constitution from Article 124 to 147, right. Let us see this sequentially, right. So in chapter 1, if you see, union executive has been dealt, and the first chapter starts with Article 52 to Article 78, right, that deals with union executive, right. Then chapter 2 deals with union legislature, means parliament, right, and the article ranges from Article 79 to Article 111, right. Then the third chapter has been dedicated only to one article, that is ordinance making power of president, right, Article 1, 2, 3, right. Then the fourth chapter, if you see, that has been dedicated to the union what you call judiciary, means Supreme Court, right, and Supreme Court power, function and other things, mode of appointment, right, salaries, all these things has been mentioned in Article 124 to Article 147. And in the fifth chapter you have something called CAG, Comptroller and Auditor General of India, and 4 articles has been dedicated to that chapter, that is fifth chapter, right, Article 148 to Article 151, right. If we break up, right now we are delving into union executive chapter, right. So if I further break up this chapter can be broken into president and vice president, right, that spans from Article 52 to Article 73. Then Council of Ministers, so 2 article has been dedicated to Council of Ministers, that is Article 74 and Article 75. So Article 74, the first clause we'll discuss in this chapter as well, because this has a relation with the president as well, right, so need not to worry. Then Attorney General, only 1 article has been dedicated, right, Article 76, and 2 articles has been dedicated to the conduct of business of executive, right, Article 77 to Article 78, right. So Article 52 to Article 70, again I am saying that you need not to mug up all the articles, just a close idea would suffice, but because many a times in prelims, right, those matching things comes, right, that relate president. So if president, Article 52 deals with the president, right, so if there is any, means you can eliminate the things, my point is. So if in options president, against president, you have Article 155, and if you have even remotely ever seen it, you would be able to know, no, 152 has been given, deals with state government, not union government, while president is in union government, and that too in union executive. So it would be somewhere 50 or 60 Article 50, so you would be able to eliminate. So that's why even if you cannot remember the exact article, although there are certain chapters, right, in which 4 or 5 articles, suppose to president, if there are 10 articles that has been dedicated to the president, there would be at least 2 or 3 articles, right, that would be necessary, that would be mandatory to remember. Article 123 that deals with ordinance making power, that will cover in this chapter, right. Then article 143 advisory functions of Supreme Court in relation to President. So such articles you cannot, means article 52 which specifically declares that there shall be a President of India, right. These kind of article you cannot afford to ignore. But then there are subsidiary articles that you can, so out of 460 or 450 article that you do have, there would be 70 or 80 very important article, and I can assure you that if you cover these articles repetitively, right, if you relate with the topic, and you will have to, anyway before prelim it is expected that every subject should be revised at least 7 to 8 times, right. So if you are revising this subject polity 7 to 8 times, I can guarantee you, yes, in initial phase there would be difficulties, right. Many starter aspirant keep asking that how do I remember these articles. So the only answer would be through continuous revision, right. There is no shortcut. See, you are not appearing for this clerical exam where you will learn mnemonic, means yes, for 1 or 2 things there may be mnemonics, there may be shortcuts, but make yourself sure that you are not appearing for a 2020 match. UPSC or state services exams are test matches, right. So it needs persistence, it needs perseverance, right. So okay, coming back to this chapter again, right. So in Union Executive you have President, Vice President, Council of Minister, Attorney General, right. So there can be one question from here itself, that what does Union Executive consist of. So Union Executive consists of these 4 things. You have President, Vice President, Council of Minister, and Attorney General, right. So that can also be a question in any of the statement of any of the prelim question, right. So I hope this structural part is clear to you, part 5 is clear to you, right, because throughout this part 3 of Lakshmikant we will be dealing with these things only, right. In Union Executive we will be dealing with these chapters. You already have this chapter on President, Vice President, then Council of Minister we already have chapter on, we have chapter on Prime Minister, then cabinet system, all these things will be dealt in this article 77 and 78, that how does cabinet function, right. Then Attorney General you already have dedicated chapter on. In Union Legislature, so don't think that the time that we are spending on this slide, whatever 5 or 10 minutes, right, we are wasting that. We are understanding the structure, right. So none of the things that I put up on the slide is useless, right. It has come with the accumulated experience, right. In initially stage it might sound that okay, somebody had told me that Lakshmikant is a standard book. See, that is a standard book only. Gone are the days when questions were limited only to the Lakshmikant. You will have to study NCERT, you will have to have some portion, grip on some portion of DD Basu as well. So here whatever I provide you here, right, that is accumulated information, right. I try to cover things, means I go through the questions, prelim asked questions, right, then I see that whether those informations are available in Lakshmikant or not. If I cannot find answers of those in Lakshmikant, I try to cover other books as well, right. So whatever information, just be sure that whatever information has been put on slide, you not ignore it, right. Now let us move to the next slide, right, and here we are entering into the first leg of our chapter, and that is President. So article 52 specifically declares that there shall be a President of India. But now the question arises that why there shall be a President of India, right. So if you remember, in first leg we had raised this question that we will be dealing with, that why the President is necessary. So if you remember, right, we are following something called parliamentary system. Our political system is not presidential system, parliamentary system, where head of government, means real decision is taken by Prime Minister of India. He is head of government. President is only head of state, means ceremonial head. Now the question arises that when all the decisions are taken by Prime Minister, why are we spending so much on presidential office, right? Because if he has to work only on the aid and advice of Prime Minister, right, why are we having this office? If I provide you some data, right, every year, last year we had spent around 67 crores, that is a humongous amount, right? So 67 crores we had spent last year only on the upkeep of presidential office, right? Staff salary, staff allowances, right, food and all, right? minus those with the tours, foreign tours of the president or security cost, right? Only the cost of office was 67 crores. So that's a humongous amount, right? So the same question, that if he is just a ceremonial head, if he is just a titular head who is supposed to work with the aid and advice, or rather completely with the advice of Prime Minister, why are we having this office, right? So let us try to reply this question, that why president office in Indian parliamentary system is necessary, right? So as of now, just consider that we do not have any president, we do not have any presidential assembly, right? We are constituent assembly right now, right? And we are debating the possibility of having any president and why we should have any president altogether when we already have assigned all the real parts to the Prime Minister, right? So to understand, to reply to this question, that why president is necessary in Indian parliamentary system, let us discuss another topic, and thereafter, after discussing that topic, we'll link it to this topic, right? So you have something called political executive. Who are these political executives? So political executives are nothing, council of minister, this cabinet minister, including Prime Minister. So how do we elect? Means cabinet ministers are nothing, those are member of parliament, right? So how do we elect our member of parliament? We do elect our member of parliament, right, through this first past post system. So in any constituency, suppose if you are residing in a constituency named Hyderabad, right? So in Hyderabad, whenever there would be general election, recently in 2019 you had this general election, so there would be, suppose, 7 candidates who have decided from different party, who have decided to fight or to contest from Hyderabad seat, right? So whosoever will secure highest number of vote, right, that person will get this MP post and he will be in parliament, right? So that is first past post system, right? I have taken a pictorial image, right? So this is first past post system. You do have these 7 candidates, A, B, C, D, E, F, G, right? So whosoever, right, secures highest percentage or highest number of votes. So here in this case, this candidate called A, he secured 27% of the vote from Hyderabad, right, and he was declared the winner. Now try to understand, this person secured just 27% of the vote. Ideally speaking, he should have secured more than 50% of the vote, then only we can consider that he is acceptable to everybody. But right now he secured just 27% of the vote, because the kind of voting system, the kind of this first past post system that we do have adopted, right, that allows a contestant to just secure highest number of vote and be the elected representative. So in this case, if you see, 73% of the people have either not voted for him or voted against him, right? So these are the 73% of the vote people who have either not voted for him or voted against him. So just by securing 27% of the vote, he could get into member of this parliament, or he can get into assembly if it is a state assembly. In state assembly as well, we follow this first past post system only, right? So he could get into the parliament, and by getting into parliament, if he belongs to the party which has majority, he can become cabinet minister, he can become member of Prime Minister as well, right? So if he has secured only 27% of the vote, that means that his core constituency lies somewhere here, right? 27 means if he could please 27% or 30%, suppose next term there is fluctuation, right? So if he could manage only 30% of the vote or 34% at max, he can again win that seat, right? So this member of parliament already knows that if I could please this 34 or 35% of the vote, means in addition to 27% that I secured this time, right, considering that there would be anti-incumbency next in next term, right? If I could please, if I could make policies, if I could have manifesto for these 30 or 35% voters, right, I would be able to get again the next term. So if the candidate or if a member knows that just by managing this 27% of the vote or 30% of the vote, I can get into parliament, right? I can be member of parliament, I can be cabinet minister, I can be member of parliament, right? Why will he work for all 100% of the people? Although ideally it is said that once, okay, whatever number of votes you have got, a candidate has got, once he becomes elected representative, once he is part of government, right, he will work for all the people. But generally that does not happen. In practice that does not happen. If a member of parliament has been elected just by managing 2 caste group or 3 caste group or a religious group, right, his priority would be, his focus would be to design policy oriented at that particular group, right? You do have various mainstream party even in states like Uttar Pradesh, right? Cannot cite the name, right, in Uttar Pradesh or in every state almost, right, who do concentrate on a particular religious group, who do concentrate on particular caste group, right, and always their primary focus, right, and that is how our political system is working, right? So leave aside this idealistic notions that okay, once in government, right, they have to work for, means those kind of idealistic notions lies only in book. So my point is, the point that I am trying to make is that the member of parliament or member of legislative assembly, those who has been elected by first past post system, right, may be driven by political interest, right? So whatever example right now I cited, right, you need not to use those kind of language either in your mains examination or in interviews, right? Our language should be like this, right? So the language would be that the political executive, means we have to say deliver the same message, but that would be a tacit message, right? So the message would be the political executive in Indian parliamentary system, especially those elected by first past post system, means just by securing 27%, the example that we just saw, may be driven by political interest, means may be focused on a particular caste or a particular religious group, and that is what it is calling, may be driven by political interest, and there must be a neutral body, right? So if they are driven by some political interest, you will see that the kind of policies that we will have, or the kind of what you call schemes that we will have, or the kind of act that will be brought in assemblies or parliament will be like this, right? So if you remember, if you know Shah Bano case, she was a lady, 62-year-old lady, it is a case of 1986. So she was a 62-year-old lady, had 5 children, and her husband had abandoned her. She went to the Supreme Court asking for the alimony from his husband. Supreme Court gave a favorable judgment and directed his husband to provide him some compensation. But then what happened, that there was a religious uproar, a particular community saw this Supreme Court judgment interference in their religious practices, right? So various kind of Maulana, various religious group created that uproar, created movement, created protest, and that built up pressure on the government. So you had this Rajiv Gandhi led government, right? So they saw that this could lead to a political loss to me, right? So finally Rajiv Gandhi brought an act into the parliament nullifying the Supreme Court judgment, right? So these kind of bills are when brought into the parliament, it is necessary, means my point is that political class or political executive cannot be, their wisdom cannot be trusted all the time, right? They may be, their decisions may be, or their policies or their scheme may be driven by what you call political interest. So in this case, if you see, the right kind of judgment was by SC, Supreme Court. So Supreme Court, because that person had abandoned this 62-year-old lady who had 5 sons to rear, right? So alimony award was obvious, she should have been given the compensation, right? But due to the political interest, because here on the one side you have one woman, right? Here on the one side you have this social reform kind of thing, right? But the society is not seeking that social reform, right? What society wants is to protect their religious interest. So that government saw that my this religious protests are taking away my vote bank, right? So they nullified this Supreme Court Act. So again the point is that this political executive cannot be trusted, means or not all the time. Of course, in democracy, when we are choosing this political executive, we cannot use this sweeping statement that they cannot be trusted. Means all the time they may be driven by political interest, right? If you see in emergency chapter, we had discussed that how various government at center level has imposed 132 times this presidential emergency, right? So although president imposes these emergencies, right, but the decision is given by council, or the suggestion is given by council of minister. Then imposition of natural emergency, if you see in 1975, that were purely by political reasons, right? Then postal amendment bill in 1982, then alleged political motive behind passage of CAA. So my point is that the political executive on occasions may be driven by political consideration. So you need to have something called president office, which is considered as a politically neutral office, which is bipartisan, which can act in an impartial manner and can say no to these kind of acts, no to these kind of presidential emergency, right? Although this 132 emergency has been imposed, right, by by pushing of council of minister by president itself, but there has been many occasion when council of minister, means if you have any idea of post independent India, there has been occasions, right, where president has been forwarded the decisions of council of minister to impose president rule in various states, but those presidents have denied. So it is because of their impartiality, because of their neutrality, right? So again, the point that I am trying to make is that you need to have a neutral office, you need to have an impartial office who could apply break on hastily passed bills, right? So if there is a arbitrary bill, right, because government most of the time, whosoever is in government, they are in government because they have majority in Lok Sabha. So if they can manage majority in Rajya Sabha as well, they can pass any kind of bill, right? So you need to have a constitutional office who can at least for some moment could apply a break, a kind of, they can at least suggest that this bill that you guys, yes, you do have majority, you do have every right to pass this bill, but at least you reconsider this bill, right? At least, because that does not lie in something called larger public interest, right? So that was the point, and that is why the presidential office, the existence of presidential office has been justified in Indian constitution. So I hope that why question, that why president is necessary in Indian constitutional scheme would have been replied. Let us move to the next slide, and now let us discuss this evolution of presidential power, right? So the text that you can see here belongs to Article 74, right? So Article 74, and it does have two clauses, right? So the one clause that is relevant for this discussion has been put up on the slide, right? So Article 74, then original text has been written. So original text, because this Article 74 has been subjected to amendment twice. So first amendment, it was subjected to in 1976, that was 42nd amendment, we will see that, right? And the second amendment, it was subjected to in 44th amendment in 1978, right? So the text that is present on this slide is from original constitution that was present in Indian constitution until 1976, right? So let us read it, right? So Article 74(1) is nothing but it defines the relationship between council of minister and president, right? So it reads that there shall be a council of minister, right? There shall be a council of minister, right, with prime minister as its head. So you have big prime minister who will be heading this council of minister to do what will be the purpose of this council of minister with prime minister as its head? So the function would be to advise the president, to advise this president in the exercise of function. So in what function this council of minister would be advising to the president? So when we'll be reading the executive function of the president in Article 53, right, you will see that all the obligation, all the contracts that government of India signs, all the important works, that, right, although the decision is taken by this council of minister, whether we need to have any kind of international treaty with any country or not, whether we need to sign any kind of convention with any country or not, whether we need to have any kind of contractual obligation. So everything that the government of India does, that is did in this president's name, right? So yes, the real power will lie with this prime minister or the council of minister, and he'll be suggesting this president, but ultimately the decision or the execution of those kind of treaty, we are aspiring to become all India services, right? So our employment letter as will be signed by none other than this president as well. So you see all the important function that government of India does, that is done in his name, and that's why it is said that there shall be a council of minister, because everything is happening in his name, right? So council, although again I am emphasizing that every decision, almost every real decision will be taken by this council of minister headed by prime minister, but that will happen in his name, and that is being said by article 53. We'll see this article 53, that all the executive power is vested in the post of president, right? So there shall be a council of minister, I'm reading it again, with the prime minister at the head to advise president in exercise of his functions, right? Now the debate that started after this operationalization of Indian Constitution. Indian Constitution was fully operationalized in what year? 1950. So immediately after operationalization of what you call Indian Constitution, this debate started whether whatever advice that is being tendered by this Council of Minister, right, to the president using this article 74, whether this advice is binding upon him or not, right? So whatever council of, I am repeating it again, the debate that started gaining momentum was that whether whatever advice that this council of minister is extending to president, right, whether that advice is binding or not. Because if you know, the oath that the president takes is, we'll discuss this oath. So the oath taken by president is to protect and maintain Indian Constitution, right? So there was a school of thought that emerged saying that because he has a duty to protect the Indian Constitution, he is the defender of Indian Constitution. So there may be chances at times that Council of Minister, driven by political interest that we were talking in the previous slide, right? So the political class at times may be driven by their political ideology, and they may pass some kind of scheme, or they may give some kind of suggestion that may not be reasonable, that may not sound reasonable on constitutional lines, or that may not be in interest of public at large, while his duty, because he has taken the oath to protect the Constitution, right? So his duty is to serve, right, public at large, right? So if there is any scheme that has been passed by government, executive means prime minister, this council of minister, if there is any suggestion that is being extended to president by this council of minister, which is vendetta driven, which is politically motivated, right, because he has taken the oath to protect the Constitution, he should not oblige to any such suggestion. And that was a school of thought, and this school of thought was led by none other than but the first president itself, right? You have this Rajendra Prasad, just a moment. So you had this Rajendra Prasad who floated this idea, although in Constituent Assembly when this debate on the powers of president was going on, he completely agreed with the principle of parliamentary system, right? What is this parliamentary system? Parliamentary system simply advocates that all the real power will lie with prime minister, while this president, right, he is current president and he is the first president. So the president will be only nominal head, right? So whatever this council of minister is saying, right, this president will have to agree it, right? But just because that 74(1) article that we were discussing, right, in 74 it is nowhere clearly expressed that whether that advice should be binding or not. This debate started, right? So this debate, as per what you call the first president, was on the lines of oath that a president is to take, right? So president, as per him, because president is protector of Constitution, he has taken the oath to protect and defend the Constitution, should have reasonable power, right? Because Council of Minister is a group of political party, and their guidance at times may be driven purely by politics, right? We saw that Rajiv Gandhi government passing a bill that was annulling that Anamoli demand of Shah Banu, right? You would have seen this imposition suggestion, president rule imposition suggestion 132 times. So what are these things? These are nothing but ideologically or politically guided schemes or politically guided actions, right? So that is what it is talking about. The Council of Ministers is a group of political parties, right? And their guidance to the president at times may be driven purely by politics, and in those situations president should have power to say no or to apply a brake. Right, so that debate started. So you have these two groups. One was constitutionalist, although this is completely my interpretation. This word has never been written in constitution, that yes, the two groups, yes, these two school of thought emerged, right? That is well documented in post-independent India's political history. This is well documented in a law school, in a convocation ceremony. This Rajendra Prasad, the first president, floated this idea. He suggested the law student to study the power relation between prime minister and president, that what power should belong to president and what power should go to prime minister. And this debate started in the constituent assembly. He had agreed, but he had this debate, right, that in such situation, right, in relation to the oath that the president takes, right, he should have reasonable amount of power to say no to the council of minister in case when there is politically driven guidance to him. Right, so constitutionalists said that no, president has a ceremonial position, ceremonial role in parliamentary system, and hence he should be guided by COM, Council of Ministers advice, and this advice is nothing but advice is binding. Right, so this is the debate that was started, right, and this debate has gone into various phases. Let us see those phases. So you have this 1950 to 1970 around phase, right. So in this debate gained momentum, and this debate kept going on between these constitutionalists and liberals. Means liberals is saying that because president is protector of the constitution, he must have reasonable power. Council of ministers means same argument, right. So this debate went around for 90s until 1970, right. In 1975, if you see, right, you had this imposition of emergency, right, by Indira Madam, and this liberals again perpetuated this idea that I was saying, मैं कह रहा था ना, मैं बता रहा था आप लोगों को कि भाई you cannot trust on the political wisdom route. Let us see what this Council of Ministers has done, right. So imposition of emergency further deteriorated the trust in the political wisdom of Council of Ministers, right. And again this school of thought, right, it was, although led, means by this time Rajendra Prasad was already dead, but yes, there were people, there was this narrative alive, right, which was continuously talking about that this president should have some amount of reasonable power, right. So imposition of emergency further deteriorated trust in the wisdom of political executive, right, and made a case for reasonable power to the president, right. So when this narrative started gaining momentum, you see 42nd Amendment, and 42nd Amendment did a lot of amendment, right. So along with lot of amendment, you will see that this Indira Gandhi government came with another amendment, and in another amendment what she did is that she inserted just two words to this 74(1) we already have seen, right. So 74(1), right, she inserted these two words, that is who shall. Let us read this article, whole meaning will be changed, right. So now this article reads, there shall be Council of Minister with Prime Minister as head to aid and advise the president. So until now it is the original article, but now who shall means president shall in exercise of the function act in accordance with such advice. Now this advice by the Council of Minister to the president has been mandatory, has been made mandatory by introduction of these two words, that is who shall. Who shall in exercise means president shall in exercise of his function act in accordance with the advice tendered by Council of Minister, right. So this is the change that this 42nd Amendment in 1976 did. Then come 1978, right, and in 1978 you had this Janta government led by Moraji Desai. So these people were group of social reformer, JP, Lohia, Lal Krishna Advani, Atal Bihari Vajpayee, right, Moraji. So these people had collectively fought against Indira Gandhi government, right, her autocratic behavior, and consequently you will see whatever amendment that 42nd Amendment did, right, that will be annulled by this 44th Amendment, and 44th Amendment, the changes this 44th Amendment is going to do to the 74(1) is this, right. So 44th Amendment along with means they did not delete this word who shall, means president is still binded by the advice of Council of Minister, but let me read it, right, provided that the president may require the Council of Minister to reconsider such advice. Let me means you can read it as soon you have PDF. I'll be sharing PDF with you guys, right? So you can read it. Let me tell you the essence, right? So what this amendment did was that yes, he is still binded by the advice of Council of Minister, but this amendment gave an option to the President that once this Council of Minister has sent advice to you, and if you find that advice need to be reconsidered because that advice is not in public interest or not on lines of constitution, then you can send at least that advice once back to Council of Minister and suggest them to reconsider that advice. Now it is incumbent completely on Council of Minister whether that they reconsider that advice or not, right? So after that, if Council of Minister, irrespective of whether those people changes this advice or not, if they have returned that advice again to the President, in that case President will have no option but to sign the act, but to assent that suggestion, right? So that is the addition, that yes, one leeway, one moderation was given to the President, that okay, once at least you can send that advice tendered by COM, Council of Minister, for the reconsideration. But after the reconsideration, irrespective of whether your suggestion, means President's suggestion, has been incorporated into that advice or not, right, you will have to sign it, right? So after that, and the President after that reconsideration shall act in accordance with the advice tendered after such reconsideration. So this is what 44, and this is how President's power has evolved a period of time. So you had that original 74(1), right, which was defining relationship between Council of Minister and President. Then you have this 42nd Amendment, which made obligatory on the President the advice tendered by Council of Minister. Then this 44th Amendment, this moderated it and provided a reconsideration, right, provided an option of what you call sending the advice back to the Council of Minister at least once, right? So this is how this is evolved. Let us move to the next slide and now discuss this election to the President, right? So because we are a republic, so the President should be elected, but the question was whether he should be directly elected using this universal adult franchise, the way we elect our MPs and MLAs, or he should be indirectly elected. So that was also a settled thing, where we had said that okay, if we are directly electing the President the way our Prime Minister or MPs and MLAs are elected, what will happen is that the dual power center would be created at union level, and there would be horizontal division of power, because if he is also directly elected, our President is also directly elected, and Prime Minister, although he is not directly elected, mind you, again I am saying we don't choose our Prime Minister. What we choose is MPs and MLAs, and those MPs ultimately get to decide that who will be their leader, and their leader get on to become Prime Minister, right? So you have a Prime Minister who has not been chosen directly, and here you have this President who has been chosen directly, popularly by the people. So there is bound to be friction, there is bound to be call for division of power. So this dual power centers, and that will result into what you call presidential assertion. If you remember, Article 74 calls for that the President needs to abide by the advice of Council of Minister, but that will not happen if there is direct election, right? That will continuously lead a spat between Prime Minister and President, right? And that will ultimately result in delay in decision making, coordination issues, continuous friction you will see, and that's why it was settled that no, he will not be directly elected, right? What kind of election then it would be? It would be indirect election, right, where you will see the electorates, that who are the electorate who participates in his election, we will get to. So indirect election. So this question has been responded. The second scenario would be that even if he is directly elected, right, what it would lead to, it will lead to more political interest. Although political interest even today it is not immune from presidential election, but if President has more power, right now he is titular head, he is nominal head, so he does not have much power, but in case if he is given power, his presidential office is given more power, you will see intense political activities when presidential election will happen, and that is not good for any democracy, right? So that will lead to further politicization of president office where neutrality, bipartisanship and impartiality is expected, right? That's why it was decided that okay, indirect election will get into. The second question was that okay, you have settled with indirect election, right? But whether it should be first past post system, the way our MPs and MLAs are selected, or it should be proportional representation, right? So this is one topic that I expected you to do homework on, right? Let me tell you, as far as this chapter is concerned, see, in first past post system, the Chandni Chowk example that we took, right, you saw that how out of 10 lakh voter, a candidate who could secure only 2 lakhs of the vote, how he was declared winner. So in first past post system, the thing that you will notice is that the candidates, elected candidate, does not enjoy wide acceptance, right? 8 lakh people in the Chandni Chowk example had voted against him or not voted for him. Only 2 lakh people had voted out of 10 lakh, and he was the winner. So he does not have wide acceptance. He has acceptance among only those 2 lakh people, right? So first past post system, the candidate that it floats, right, that candidate is not widely acceptable. But this office, president office, right, which is expected to be a neutral and impartial office, he needs to have a wide acceptance, right? And that wide acceptance is given by proportional representation, right? And that's why it was decided that we should not get into this first past post system as far as presidential and vice presidential election is concerned. So such neutral post should be elected by what you call proportional representation. So these two questions I hope has been answered, right? So after having discussed this, let us move to the next slide and let us discuss the Electoral College. So Article 54 discusses the Electoral College. So Electoral College, the meaning of Electoral College is that who all will be part of this voting process. So Article 54 talks about the Electoral College. So you have all the elected members of Lok Sabha. Mind you, I am telling you that elected members, not the nominated members. Then elected members of Rajya Sabha, then elected members of the state assemblies, right? And then elected member of union territory which has legislative assembly. So which all union territory have legislative assembly? You have this NCT of Delhi, then Puducherry, and the newly created union territory, that is J&K. But mind you that this J&K, Article 54 is yet to be amended to include J&K assembly as far as the Electoral College of President is concerned. So as of now, the update is that the J&K is yet to be included, right? So as and when this Article 54 is amended, you can update this, right? So as of now, the information is that J&K assembly is not part of the Electoral College for the President, right? So who all are missing here, right? So the missing people are these, right? So you have member of Legislative Council. So you have these 6 states which have, mind you, again the Andhra Pradesh has recommended for the abolition of Legislative Council. This J&K, which earlier has what you call upper assembly, right, Legislative Council. This J&K right now is a unicameral legislature. So this 2 state, right, although Andhra Pradesh recommendation perhaps is yet to be accepted by Parliament, right, but they have passed the resolution. So be careful about that part as well. So members of Legislative Council of the states, right, so those will not vote, right? And the logic behind is that you have to, in election of president, you have to maintain uniformity in his election, right? And how uniformity? If you include Legislative Council members from these 6 or 7 states, right, other state does not have Legislative Council, right? So it will be discrimination with those people, those state which does not have this Legislative Council. So member of Legislative Council won't be part of president election. And then if you notice, right, we have expressly mentioned that elected member of Lok Sabha and elected member of Rajya Sabha. So nominated member of these Lok Sabha and Rajya Sabha would not participate. So why a nominated member of the Lok Sabha and Rajya Sabha will not participate? Everything is driven by logic here. You need not to cram anything, right? So why nominated members would not form part of this Electoral College, or why nominated member will not participate in his election? So please try to understand. Who are nominated members? Nominated members has been nominated by whom? President itself, right? So if they are allowed to participate in presidential election, it will lead to conflict of interest, right? Under Article 80, you have this provision: President has power to nominate 12 members into Rajya Sabha, and under Article 331, President has power to nominate 2 Anglo-Indians. Until now, he has power, but after 126th Amendment, that provision has also been abolished, right? So you will no longer see that nomination of 2 Anglo-Indians, right? Just get to see that 126th Amendment bill, right? So the point is that if the nominated member is allowed to participate, so suppose whenever his term ends, right, he gets to decide to file for the re-election, right? So he has nominated these people, these 12 people in Rajya Sabha. So ultimately they might favor this person itself. So that will be a discrimination with the other candidates, right? And even if he does not stand for contest for the re-election, there would be some other government supported candidate, right? And it is not the president who nominates, president formally nominates, but the nomination proposal is forwarded by Council of Minister, right? So the candidate that will be supported by government, right, those 12 nominated member will support that government supported candidate, and that's why this nominated members are not allowed to participate in the election of president. They will not be part of. So everything is driven by logic. You need not to cram anything, right? You understood the logic of not having these members of Legislative Council of few states in the Electoral College. You understood why nominated members cannot be part of this Electoral College, right? So I hope you have understood it. So who all, let us revise it, right, once again. So who all will part of this Electoral College? So elected members, again emphasizing, elected members of Lok Sabha, then elected members of Rajya Sabha, then elected members of State Assembly, not nominated member. Even in State Assembly you have one nominated member by governor, right? And the governor is appointed by whom? President itself. So governor is agent of president itself. So that will also lead, if he is allowed to vote, that Anglo-Indian in State Assembly, then again that will lead to conflict of interest. That's why the pointed expressed provision is that only elected members in the State Assembly, right? Then elected member of NCT of Delhi and Puducherry, right? JNK has not become the part of Electoral College until now, right? Then what would be the election method? We already have discussed the election method would be proportional representation, but one more word has been added, and that is proportional representation by single transferable vote, right? See, the content is ready to make you understand that what this proportional representation by what you call single transferable vote is, but I won't be able to cover it considering that prelims are closing by, right? You have this prelim, considering that if it does happen on 31, we won't be able to cover whole of the syllabus, right? That's why I'll be now onwards, I'll be focusing only on high yielding topics, okay? If time allows, right, we'll get into the details. So all the candidates were ready, the Electoral College was ready, all the things, how the elimination in single transferable vote happens. So all these things were ready. It's just that the explanation is necessary. But if I decide to explain you these things, this will again entail half and another hour, right? And the time is only resource that perhaps we do not have, right? So as of now, just cram this concept, although I have never recommended you guys to cram anything, but here I'll say that okay, cram this concept. The president is president's election happens from this proportional representation by single transferable vote. Will not explain it, right? Then whip is not issued in the voting of president election. So this can also be a provision into any of your prelim questions. So why whip is not issued? I don't know whether you know about whip or not. So allow me, this is a small concept, so allow me to explain it. So whip is nothing but a political dictate issued by party chiefs, right, to their member of parliament or member of legislative assembly, and that whip will decide that what way these MLAs and MPs will vote on a particular bill, right? So if the party says that okay, you say yes to this bill, the party man has to follow that whip, right? If they do not follow that whip, if they do not follow the party dictate that has been, every every political party rather have a whip leader into every house, right? So if the people does not vote in the manner, member of parliament or member of legislative assembly does not vote in a manner, even after whip has been issued to them, right, they will be subjected to anti-defection, right? So that is what whip is, that it is nothing but a political dictate issued by party chiefs. It is a party stand simply, right? But in election of president this whip is not issued. Let us try to understand that why in election of president this whip is not issued. So let us understand this whip, right? So whip is nothing but ultimately it is, again we can have a separate debate on whip as well, that how does it interfere with the independent functioning of member of parliament or member of legislative. So let us understand in short. So here you do have MP, let me grab the pen. So here suppose you do have MP or MLA, elected representative. He has been chosen by these people, right? It is their electorates, right? And here on the other side you do have this party chief. Now party chief wants this MP or MLA to elect a candidate A, right? While the electorate want नहीं B वाला जो candidate है, he is more popular, he is Abdul Kalam type, and B should be voted, right? So if the party chief issued this whip, right, ultimately people choice will not be respected. He will be guided by this party chief's whip, right? So who should have been given more importance, party chief dictate or people's will? He do have more responsibility toward, yes, he do have responsibility toward party as well, because ultimately it's on the party ticket that he has won the election, right? But if we do compare that whether party chief or electorate's interest, electorate choice, so from my understanding it is electorate's choice that should be given more importance. And if electorates wants his elected representative to vote for B and not for the A, right, it is this thing that should be respected from my understanding. And it is for this reason that whip is generally not issued in the election of president, because president is a neutral office, president is an impartial office, and president is not of a state or not belonging to a political party, it is for the whole country, right? And that's why you have whip not being, means provision of whip is absence here, right? So whip is not issued during voting of president election, and from here drives the next point that the election shall be held by secret ballot, right? So these are nothing but keywords. So whip, you need to remember that in election of president whip is not issued, then election happens by secret ballot. Why not open ballot? So open ballot, see, whip has not been issued, means legally or technically party cannot issue whip that okay, you vote for this candidate or you should not vote for this candidate. But informally even now they can issue a dictate that okay, formally we cannot issue this dictate, but informally you vote for this candidate. And if it will be by open ballot means his colleagues or party chief can see that okay, in what manner he has voted for which candidate, what preference he has given. So if it will be by open ballot, he will have to show it to party chief, party whip in that house, right? So he would be able to see, and if there is an informal dictate, right, there are chances that he or she will be harassed, right? That's why the secret ballot concept. So in secret ballot, once he has mentioned the preference that okay, this to this candidate I am giving first preference, to this candidate I am giving second preference, after that he can simply just submit it to the secretary of the house, right? That's why this secret ballot concept. So everything that you saw here is driven by logic. There is nothing that you need to cram. So secret, what are the keywords that you need to remember? Secret ballot, whip, election methods through proportional representation by single transferable method, then council, legislative council do not participate, then nominated member cannot participate owing to the conflict of interest. Here only elected, because nominated again seem logic. Then elected member of state assemblies, nominated will not participate. J&K so far has not been included. So these are the points, that key points that you need to remember for the election of president. So this is one example of whip, where recently in Madhya Pradesh, when you had this assembly floor test, Congress and BJP had issued whip to their MLAs to decide that okay, you should vote in this manner and you should not vote in this manner, right? Thereafter, can election be challenged? So once a candidate has been declared winner after the election, can his candidature or can his election be challenged? The answer is yes. So article 71 mentions the ground of that challenge, right? So article 71 empowers parliament to enact some law which will have certain grounds, right, on which this election can be challenged. And in pursuance of power extended to parliament under this article 71, you see parliament has already enacted Presidential and Vice Presidential Election Act 1952, right, which has grounds mentioned on which election can be challenged, right? So election commission conducts the election of vice president and president. It is their responsibility to, so the candidate who has contested against the winner, right, he does have locus standi to file a election petition, but that election petition should be filed within the 30 days of declaration of result. So along with what you call contestant, if contestant does not want to file what you call election petition, right, then other thing is that the 20 elector as well can file this election petition, and that election petition will be filed in Supreme Court. So Supreme Court has that exclusive authority, and whatever decision that Supreme Court extends, right, that will be final, right? There is no appellate jurisdiction of any other body or any other court, right? So if Supreme Court find that the candidate on against which this election petition has been fined, if he has indulged in any kind of electoral malpractices, or if he was not eligibility criteria that we'll study right now, right? So if he was not fulfilling any of the eligibility criteria, although on papers he claimed, right, then his elections will be declared void. And in case his election has been declared void, and if he had already assumed the office and done certain acts, passed certain acts, so in that case acts passed or any of his acts will not be validated. Even if his election has been declared void, right, his acts that has been passed or any of the act that he has done, that will not be invalidated, right? So along with election, EC conducts the election. Election notification is generally issued 60 days before the expiry of the incumbent president, right? So I hope election of the president would be clear to you. That method we have not discussed, that is pending. So if time allows, I'll do that. So this is first past post system. This is proportional representation. What are the advantages? What are the disadvantages? Right? We already have done that. Content was ready. Right. So along with this election method, let us discuss the impeachment method as well, because there are certain overlaps between impeachment and what you call election method. So let us do that. So impeachment, if you see, the grounds of impeachment has been mentioned in Article 56. So Article 56 says there is only one ground on which president can be impeached, and that is violation of constitution. So that has been mentioned in Article 56, while Article 61 decides the manner in which this president will be impeached, right? And mind you, one word, that this word impeachment has been used in Indian constitution only in a reference to president. So all other constitutional functionary, be it vice president, be it CAG or UPSC, they all will be removed from the office, right? This word specifically impeachment has been used only for president, and that only in Article 56. So Article 56 tells you the ground on which president can be impeached, and Article 61 decides that okay, what will be the manner in which president will be removed. So president will be removed by special majority. The process we will see, right? Just keywords we are looking at. So he'll be removed, sorry, not removed, impeached. I am using the wrong words, right? So special majority he will be impeached by, and that special majority has been mentioned in Article 61. And mind you, the special majority of Article 61 is totally different from special majority that has been mentioned in Article 368. So Article 368, you have those two terms, that is absolute majority plus 2/3 of the present and voting. But in this case, the special majority that has been mentioned, it is 2/3 of not present and voting, but 2/3 of total membership of the house. So what is the total membership of Lok Sabha? 543, if we set aside the two Anglo-Indian, right? And what would be the total membership of Rajya Sabha? So some 245. So when special majority is said in relation to Article 61, that is in relation to impeachment of president, right, it will be 2/3 of the total membership of Rajya Sabha and Lok Sabha. I hope you do have clarity. So let me emphasize again that the special majority that has been mentioned in Article 61 in relation to the impeachment of president, that is totally different from special majority of Article 368, right? You do have special majority under Article 249 as well. You do have special majority under Article 61 as well, and you do have a special majority under 368 as well, right? So these three kind of special majority, but this Article 61 is totally different. If you see the electoral college for the impeachment of president, so electoral college, only these people will participate in the impeachment of president, right? So all member of Lok Sabha and all members of the Rajya Sabha. If you remember in the previous slide, for the election of president, not all the members of the Lok Sabha were participating, right? Only elected members of the Lok Sabha were participating and elected members of the Rajya Sabha. But here all members of Lok Sabha and Rajya Sabha can participate, and the logic is that the conflict of interest, if nominated members are participating in the impeachment process, the conflict of interest, the factor that was coming in the election, that conflict of interest won't come here, right? What is the other difference from in the electoral college of impeachment and election? So the other difference is this, right? You had the state assembly as well who were participating, but in the removal, in the impeachment process, state assembly will not have role, right? Thereafter NCT and Puducherry's assembly was also participating, right? So they will also have no role as far as impeachment is concerned. So these two people are missing, these two bodies are missing. Thereafter instead of elected, all member of Lok Sabha and all members of Rajya Sabha, and that's why immediately after election I had put up the impeachment. Otherwise we do have discussed eligibility criteria and oath, thereafter impeachment would have come last, but just to have this comparison, right, I had put up immediately after election method, this impeachment method, right? So what would be the process of impeachment? If you do have clarity on electoral college for the impeachment, let us move to the next step and let us see what you call the process of impeachment, right? So here let me remove this. So impeachment process can start either in Lok Sabha or Rajya Sabha. It can start in both the houses. So suppose a party levels the charge that the President Ramnath Kovind, again hypothetical case, no offense to Ramnath Kovind ji, our Prime Minister. So suppose against the incumbent president, right, will not name him, right, a particular party want to press the charge that the president has violated the constitution. So what so suppose he presses, means this resolution can start, for the removal of resolution can start in any house. So suppose the party wants to decide to move this charge from the Lok Sabha. So Lok Sabha will press the charge, but that party will have to make sure that 1/4 of the membership of the house where he wants to initiate the resolution, 1/4 of that house members should support that resolution, that yes, the president has violated, means the party will have to agree at least 1/4 of the member, and even if 1/4 member agree, right, they will have to give this prior notice of 14 days. Once this notice has been served to the president, this 14 days notice, thereafter suppose in Lok Sabha this resolution has been moved, right? So Lok Sabha, so after passes of this 14 days, Lok Sabha will have to pass that resolution, that motion, with 2/3 of total membership of the house. So you have 543 members, so 2/3 of 543 members if agree, right, then only that resolution will be passed. So once if Lok Sabha passes that or Rajya Sabha passes that, right, it will be sent to other house, right? Once it has been sent to other house, mind you, this process is a quasi judicial process. And why quasi judicial? Because if one house has pressed the charge, it is the duty of other house to investigate the charge, right? Just a moment. So other house will not only move the resolution, it will also have a body, right, which will investigate the charge, that the charges that has been pressed by Lok Sabha or Rajya Sabha, whether those charges are true or not, right? So one house has already passed this resolution, it will be sent to other house, the other house will investigate the charges, and if the other house also sustain the charges that yes, violation of constitution president has indulged in, so they will have to pass again this resolution plus investigation with 2/3 of the total membership of the other house, and if the other house also passes that resolution, president will stand impeached from the day on which the other house passes that resolution, right? So this is the process of impeachment of president. I hope that you would have clarity on this. Only president can be impeached, others are removed. So this portion we already have discussed, right? So let me move this thing again here. Where is the mouse? Let me move this tool. So I hope you do have clarity on this process of impeachment, right? Let us move to the next slide, right, and let us discuss the what would be the qualification. Although qualification we should have discussed, qualification and eligibility criteria and oath and all, right, immediately after election, but because again we had to compare the Electoral College, and that's why qualification has been put later to this impeachment. So what are the qualification? And the first qualification is that he should be citizen of India, and here from this provision, right, because in constitution only this part has been mentioned, that he should be citizen of India among other provisions, right? So the implied question is that the can naturalized citizen as well file for the can run for presidential office? The answer is yes, right? So unlike US, where only born citizen, means American born citizens, can run for presidential office, in India you have this naturalized Indian as well, they can run for this presidential office. The second criteria is that he should have completed this 35 years of age. Now if you notice, the lower age limit is mentioned, but there is no upper age limit, right? So even if you are 87 years old, 88 years old, right, there is no provision, constitution is silent on this. So unlike other constitutional functionary like CGI and High Court judge, which have that upper age limit, right, here in this case you do not have any upper age limit. The third criteria, the third qualification is that the person who wants to run for this presidential election should be qualified for the election in Lok Sabha, right? The fourth qualification is that he should not have held this office of profit that has been mentioned in Article 102, right, under Government of India or any state or local government, right? There are certain offices which are exempted from this office of profit definition as far as presidential election is concerned. So if you are holding post like president or vice president or council of minister in union government or council of minister in state government, right, you can still run for presidential election, and those offices will not be considered falling under this office of profit. So those offices of president, vice president, council of ministers in union government and council of minister in state government, those offices has been exempted, right? And next qualification is that the nomination of presidential candidature must be subscribed by 50 proposers and 50 seconders, right? So many people does have confusion between this proposer and seconder. Everybody although know the proposer, that okay, if anybody wants to run for this presidential election, right, he should be proposed, his name should be proposed by 50 MP or 50 MLAs or collectively, right? So proposer everybody understand. What is this seconder? So seconder is nothing. So suppose I float an idea, so I would be proposer of that idea, but you support me, you say that okay, I support your idea, so you will be seconding my idea, right? So that is what. So 50 people will say that yes, if this person, I am proposing this person, if this person runs for presidential election, I'll support him, and 50 people should say that okay, if he has been supported by these 50 people, we support this idea. So those people, those 50 people will come under this definition of seconder. Earlier these numbers were somewhere 2020, right? So you had frivolous filing of candidature to the president office, and just to avoid those frivolous nominations, right, this numbers has been increased, right? So I hope qualification criteria would be clear to you. Now if you remember, if you have been keeping political history of India into the notice, you would remember that when Pranab Mukherjee in 2012 was elected for this office, right, P.S. Sangama, who was opposition candidate, right, he had dragged his election into the court, right? P.S. Sangama's allegation was that while he was contesting election, Pranab Mukherjee was contesting election, he was holding an office of profit. ISI is an institute based in Kolkata, right, Indian Statistical Institute, right? So he was chairman or some president, Pranab Mukherjee was president of that ISI. It's not Pakistani ISI, it's Indian Statistical Institute, right? So on that ground, I mean, Pranab Mukherjee's election had been dragged into the court. This P.S. Sangama had filed election petition, but ultimately Pranab Mukherjee came out and he became president, right? So that is just another example that okay, these cases can be dragged into court, right? Then oath and affirmation. Along with oaths and affirmation, we may claim it as duty as well, right? So oaths and affirmation of president has been mentioned in schedule 3, right, because it is here in this schedule 3 that oath of union minister and council of minister and all those people MLAs has been mentioned, right? But stop, his oath, president and governor oath, is not mentioned in schedule 3. The oath of president has been mentioned expressly in article 60 itself, right? Here you do have union minister. If you want to see, you can have a glance over schedule 3, right? Here you do have snapshot. So in third schedule, where oath has been mentioned of the constitutional functionary, here you do have only union minister and state minister, then MP candidates and MLAs candidates, then judges of Supreme Court and High Court, and CAG offices. So these 6 or 7 offices oath has been mentioned in schedule 3. Do you find president here anywhere? No, president and governor as oath has been mentioned directly into the constitution in article 60. Right? So oath of president. Now who will administer the oath of president? So oath of president is administered by Chief Justice, and in his absence any of the senior most judge of Supreme Court will administer oath. So what oath does he take, right? So it is not actually again oath but duty as well of president. So he takes, along with other provision, that okay, I swear by to execute my office faithfully and I'll discharge my duty faithfully. So along with all those provision, the different thing is that he also takes oath to preserve, protect and defend the constitution and law. And that's why you had in 2017 or 2018 a prelim question that who is considered as protector or defender of the constitution, right? And you had this option of Supreme Court as well, right? So many people had marked that Supreme Court because it may be confusing, right? If laws are passed, various laws are, who decide that whether a law is constitutional? So Supreme Court ultimately. So ultimate protector in our constitution or ultimate protector in our country is considered as Supreme Court, right? So many people had this confusion, right? But if you go by the oath of president, right, you will see that he is actually preserver. So only governor and president takes this different oath to preserve, along with other provisions. There are other provisions as well that okay, I'll discharge my duties of office faithfully and all these stuff. So along with other provision, he takes this different provision. So this is the only difference between the union minister's oath and president's oath. So president and governor takes oath to preserve and protect the constitution, right? So I hope oath is also clear. So qualification, so far we have covered election, impeachment, qualification and oath and duties, right? We already have covered. Let us move. So what are the privileges and immunities? So privileges and immunity of president, if you see, has been covered in article 361. So while a president is in office, while he is in his tenure, no court in India, either subordinate or high court, right, should issue any kind of notice to the president or governor, right? I'm just for the purpose of comparison I'm putting the governor, otherwise governor chapter will cover separately, right? So no court in India, either subordinate or high court, right, should issue any kind of notice to the governor or president, right, for any of the exercise in his official capacity, right? Then he enjoys complete immunity for criminal acts, right? And here is the catch, both in official and personal capacity, right? So criminal acts, immunity in matters of criminal act, both in, or not only in official but even in personal capacity, right? And this is actually exception of article 14. If you remember when we were discussing this article 14 in fundamental, right, president's office has been exempted from that right to equality. That is an exception, right? And exception is because of this provision or this privilege that has been extended to president, right? So enjoys complete immunity for the criminal acts both in official and personal. See, in official capacity, if he has been given some exemption, that is understandable, but he has been extended this immunity in personal capacity as well. So tomorrow if president or governor, right, if they accidentally murder someone, right, during the term, right, they will be exempted from any kind of notices or any kind of warrants from any court, right? So that is something that is totally different, and that is not actually violation, that has been mentioned in article 40, that exemption or exception has already been mentioned, right? So that was about criminal what you call immunity in criminal matters. What about in civil matters? So in civil matters, as far as official acts are concerned, total exemption again. But in personal affairs, if he violates means on personal level, if president has some contractual obligation towards me, right, at personal level, so in that case I can sue the president again, not president Ramnath Kovind, right, I can sue him, but only after this 2 months notice, right. So in civil matters, in criminal matters, complete immunity, right, both in official and personal capacity. But as far as civil matters are concerned, in official capacity, whatever function that he exercises in official capacity, nobody can sue him, he has immunity. But in personal affairs, right, at personal level, if he does violate any kind of contract or any kind of obligation, with a 2 months prior notice, right, he can be sued, right. So that is about privileges and immunity that has been mentioned in Article 361, right. Let us discuss the term. So term we already know, 5 years, right. He is eligible for re-election any number of times, right. So that is again different from US constitution, right. US president can run only for 2 terms, right. So that is one difference. Can resign from the office by writing to the vice president. So if president has to resign, he will write that resignation letter to, address his resignation letter to vice president, right. But now vice president will have to inform this resignation to the speaker as well. What is the logic? Why vice president need to inform when resignation letter has been addressed to vice president? Why vice president need to inform it to speaker as well? Because president belongs to the people, and it is the Lok Sabha which is considered to be the people's house, right. So people should know, people should be aware that their president has resigned, right. So that is the logic that runs behind that vice president, on receipt of resignation letter from president office, he first need to, it will be his duty to inform to the Lok Sabha speaker, right. So that is something that has not been expressly mentioned in Lakshmikant, although vaguely it has been mentioned, but not many candidates, not many aspirant focuses on these things, right. Thereafter, vacancy. So vacancy in the office can be created either due to expiry of term or death or resignation, right. So these all can be the reason, right. So it may be due to expiry of term. Just a moment. So it may be due to expiry of term or death or resignation or illness or impeachment. So far nobody has resigned yet, right, and so no president has been impeached, right. So no vacancy has occurred into the president office either due to resignation or impeachment. As far as death is concerned, yes, 2 president has already died while in office. So you had this Zakir Hussain and Fakhruddin Ali, the famous Fakhruddin Ali Ahmad, who had signed that national emergency in 1975, the controversial national emergency. So these two people have died in president office, right. So now if the vacancy is to be caused due to expiry of term, so this is not something unexpected, right. Every 5 years this vacancy occurs. So in that case, election commission should conduct election at appropriate time to ensure that the new president assumes office before this expiry of the term of the incumbent, right. But if the vacancy is created not due to the expiry of term, it is either due to death or resignation or impeachment, so these all activities would be sudden, right. If somebody has died, right, election commission is not at fault, right. They did not know that a president is about to die. Or if somebody has resigned, right, he will not inform election commission that I am going to resign 6 days down the line, right. It is not. If somebody has been impeached, again election commission will have no time, right. He can be impeached within 2 days if house is in session, right. So in these cases, election commission will not have time, right, and there will be vacancy in the office, right. In these cases, if vacancy has occurred either due to death or resignation or due to impeachment, right. So in that case, election commission must ensure. In the first case, when it was due to expiry of term, right, election commission already knew that okay, in 2022 or in 2023, in so and so month, this the incumbent's term is about to expire, right. So he can plan, right. You would have seen in the previous slide, right, 60 days before the expiry of term, Election Commission issues the notification for the president election. So that can be done in planned manner, but in these cases when vacancy has occurred due to death or resignation or impeachment, right, Election Commission will not have time, and there will be vacancy if some president has died, right, so there will be vacancy, but it is to be ensured that the vacancy never occurs in what you call president office, right. So to avoid that vacancy, the provision, the constitutional provision has that in absence of or in case of resignation or death, right, vice president will assume the office of president. If vice president is also not present, right, Supreme Court's Chief Justice of India, right, if CJI is also not available or if he does not want to take functions, it's Supreme Court's senior most judge. So this is the sequence in which these constitutional functionaries may assume the charge of president office if president office has been vacated due to any of these reasons, right. And in the meantime, Election Commission must ensure that within the 6 months of vacancy created, right, the Election Commission has to conduct the election, right. So I hope this vacancy would also be clear to you, right. And in another case where vice president, Supreme Court CJI and senior most Supreme Court judge can exercise or can be president, and that situation is that if the president is absent either due to illness or if he is on a long foreign tour, right. So in these cases, if you see, if he is unable to discharge official functions on account of either absence, foreign travel or illness, right, vice president shall assume president's function, right. Vice president, if he cannot assume, again the same sequence, Supreme Court Chief Justice of India. If he is not present or if he does not want to assume the charges, senior most judge of Supreme Court, right. And while these people are acting as a president, right, same immunity, same privileges, same perks that president had, right, the same immunity will be available, same privileges will be available to all these people. Most judge acting as president enjoy all powers, immunity, salary, perks, privileges of the president, right. So I hope this vacancy thing is also clear to you. Let us move to the next slide and let us discuss the powers and functions of the president.